Thank you everybody for attending today's seminar, particularly on a very wet and stormy afternoon. My name is Stephen Ip and I'm a barrister at Greenway specialising in construction disputes. I presented a seminar in March last year on the Court of Appeal decision in Pafburn. This led me to reach out to my colleagues at Clyde & Co, James Rigney on my right and Stephen Lurie on my left, to co-present on the High Court's decision in Pafburn. I'm currently acting in a number of matters which concern issues arising out of the High Court's decision in Pafburn. I'm delighted to hand over to my colleagues at Clyde & Co, starting with Stephen. Thank you.
Thank you. So I'm a special counsel at Clyde & Co. I've practiced in professional indemnity for the last 20 years and in the last 5 or 6 years almost exclusively for multinational engineering firms arising from big infrastructure disputes across the whole gamut of engineering disciplines. Today I'll be talking about what was not decided or questions that remain from the decision, as well as impacts of the decision on consultants and other subcontractors, because that's who we act for. Before the High Court's decision was handed down last year, in our team alone we had about 9 matters which were awaiting the outcome of the decision, and it's obviously a matter of very wide public importance. James.
Thank you, Stephen. Good afternoon, everyone. My name is James Rigney. I'm a partner from Clyde & Co, an international law firm. I'm based here in Sydney. We have 2 of our core sectors being construction and insurance, so hopefully I'm in the right place today. I specialise in defending construction professionals in lawsuits and advising insurers on associated construction risks. I'm part of the construction PI team, which is headed up by Matthew Smith here in Australia. We're nationally integrated. Stephen Lurie is a part of that. We're globally connected as well. And we're really passionate about this sector. It's been a real driver of growth for us, so we're super excited to be here. In fact, we were so excited we were writing many articles about Pafburn with Stephen and Henry Bloor and myself, and hence Stephen was kind enough to reach out to us. So thank you, Stephen, for the introduction and organisation, and thank you to Greenway Chambers for your hospitality as well. Today, I'm going to be talking about Pafburn's impacts on the construction and insurance sectors. So I look forward to talking about that, but back to you, Stephen.
Thank you very much, James. I'm now going to discuss the topics that we are going to cover this afternoon. You'll see that how we've broken down the discussion. I'm going to attempt to move rather rapidly through these 7 points, really to give you a structure of how the decision came to be and unfolded at its various levels. And then Stephen, as he's said to you, is going to talk about what was not decided and try and unpack some of the questions that remain, that those of us who've been advising from the owner level and then at the certifiers, engineers and insurers, for example, are going to try and deal with what are the impacts. And James is going to bring to bear his expertise and specialist expertise in relation to insurance matters and discuss the impacts on the insurance industry. And then finally, I'm just going to make brief reference to legislative reform and what that might mean. At its heart, understanding this decision means one has to grapple with the intersection of 2 perhaps competing statutory acts. And as the Court of Appeal and most recently the High Court made clear, the goal is to ensure that a seamless interaction between the competing policy perspectives of the 2 acts is construed and interpreted so that the outcome balances the competing policy objectives. One of the talking points that James, Stephen and I have is to ask ourselves the extent to which that policy objective has been achieved. And that's something that we're going to invite each of you to discuss with us at the end of our talk and to get your thoughts as to whether you think that balancing exercise has been achieved Most of us here are familiar with the principal issue that was decided by the High Court. The slide before you puts the proposition succinctly, taken from the appellant submissions. The issue was whether and how a damages claim under Part 4 of the Design and Building Practitioners Act is an apportionable claim under Part 4 of the Civil Liability Act. Now, before you understand or attempt to understand Pafburn, we need to go back in time, and this concept of going back in time we will return to again as a familiar theme to this discussion. In 2000 there was the insurance crisis, and James will be better equipped than most to talk about the impact of that on public liability insurance and the public community pressure that arose as a result. James, do you want to comment further on that?
So, I mean, I wasn't practicing in 2000 for the record, but I was getting close. But I was familiar with kind of what was happening around that time when I came into practice. There was what's known as the insurance crisis. There was a collapse of a major insurer in Australia, and people were crying out as a result of that, saying that litigation costs are too expensive, insurance premiums are rising, and so that was what was known as the insurance crisis, and that then resulted, I don't want to steal Stephen's thunder, but it resulted in the introduction of the Civil Liability Act, and that resulted in the introduction of the proportionate liability regime that we'll be discussing here today, which allowed the pleading of proportionate liability defences. Now, what's interesting is the Civil Liability Act was introduced to reduce insurance premiums and litigation costs, and now what's happened is, as a result of Pafburn and its constraining of the proportionate liability regimes, it's actually resulting in increased premiums and litigation costs. So we're kind of back where we started.
Thanks, James. And so my short point here is to follow on from what James has said is we have a crisis of some kind and we have a legislative response. In this case, we're talking about the response, as James said, that led to the Civil Liability Act. That, of course, being a federal government response. Now, after the Civil Liability Act had been in play for some time, we of course come to the Brookfield decision, and the slide there records what the High Court decided in the Brookfield decision. So you have a position where the head builder of a strata title serviced apartment doesn't owe a tortious duty of care and common law to subsequent owners. What happens next? We have two significant events in New South Wales. In December 2018, the Opal Tower incident, and that I think it may, due to the passage of time, and not resonate as much now for those looking at it, but at the time it was a most significant issue. Remember, approximately 3,000 people are forced to evacuate in the middle of the night from their home, and with the significant risk of major structural damage occurring and property damage and damage to persons. And the outcry that followed as a result of that, coupled with the June 2019 Mascot Towers incident, was similarly, we're talking about high-rise residential apartment buildings with major defects.
And Stephen, just the Opal Tower, the other thing to bear in mind, that was Christmas Eve, so not just December, it was Christmas Eve. You have these poor punters walking out in bare feet to not enjoy Christmas, basically.
Yeah, the prospect of losing their homes, their major assets, etc. A monumental impact. And the state government responds, and the state government responds with legislative change. And there's an initial report which leads to the Design and Building Practitioners Bill. And if you read the first and second reading speeches of the bill, you'll get a very strong flavour of government pressure to do something to protect homeowners in the face of this considerable risk. And this is, of course, in the light of the pre-existing Brookfield decision, where owners are facing the prospect of not having any ability to make a recovery. So the legislature responds and introduces this legislation. Now, I just want to put up on the slide for those of you who just want to get a flavour of what the nature of the discussion at the second reading speech by the member, to clearly articulate that this is a crisis of consumer confidence that requires government action. Now, the slide here explains the forerunner to Section 37, and is explaining the concept of why the duty of care will be extended, and it's of course intended to not apply to sophisticated entities and those who are able to contractually and financially protect their commercial interests. So it doesn't apply to owners who are developers who are large commercial entities. Section 36 is a critical section to understand when seeking to apply the Section 37 duty. And for the purposes of the Pafburn decision, Section A, building work, and D were the material sections that were construed by the courts. I'll come back to the intersection of those two sub-provisions and try and articulate some of the arguments that were made before the court. But perhaps if you could just bear that in mind as we travel through the sections. Section 37, of course, is the principal provision we're concerned with. And you'll see 37 subsection 2 in the form that it appears on that slide. Now, the relevance of 37.2 to bear in mind is that's the direct expression of the legislature changing the effect of Brookfield. Two further provisions to be familiar with, and provisions, particularly Section 39, that loomed large in the High Court's interpretation, indeed the courts below. Section 39 introduces this concept of a non-delegable duty, and of course provides that a person who owes a duty of care under this part is not entitled to delegate that duty. And then Section 41 introduces this concept of the relationship or interaction between Part 4 of the Design Act and the Civil Liability Act. Moving on to the Civil Liability Act itself, a quick reference to Section 5Q. Section 5Q introduced as part of the legislative civil liability reforms in 2002. And when we look at the first instance decision and then the Court of Appeal decision, the interpretation of how and whether Section 5Q applies loomed large in those courts' considerations. Most of us will be very familiar with the facts of the Pafburn decision. I've attempted to set them out briefly in the slide that's before you. An owner's corporation suing a builder and a developer, and the builder and the developer filed defences in which they raised proportionate liability defences under Part 4 of the Civil Liability Act. The case comes before Her Honour Justice Rees on a strikeout application, and it's relevant to be conscious of the fact that it's a strikeout case. So when the case got all the way up to the High Court, one of the issues that the High Court faced was effectively they were trying to resolve issues that were effectively at an interlocutory stage on pleadings. And the High Court said a number of times, effectively, we don't have all of the facts which we would ordinarily expect to have to decide a question like this, but that's the way in which the vehicle for this dispute had travelled through the courts and been presented itself to the High Court. Very briefly, at first instance, before Her Honour Justice Rees, Her Honour found that the proportionate liability provisions of the Civil Liability Act do apply, and so that the claim is apportionable. And the principal point of reasoning was that the Section 37 duty of care is a statutory tort. It's not a tort in the common law sense. And the impact of that is the Section 5Q that I showed you a moment ago. If we just quickly go back, attempt to do that. If you look, you'll see the first line, the reference to liability in tort. So the argument is it's a statutory beast, it's not a common law tort, so Section 5Q is not engaged. Now, that's the critical issue that was taken up very strongly in the Court of Appeal and then in the High Court. Turning then to the Court of Appeal decision, the principal judgment was written by His Honour Justice Baston, essentially with whom Justice Adamson and the Chief President Ward agreed. His Honour Justice Baston took a different view to Justice Rees below in considering whether Section 5Q was engaged on the basis that effectively it was a tort within the meaning of Section 5Q, and His Honour also reached the view that one had to read Civil Liability Act proportionate liability provisions together with the Design Act provisions together in a way that would produce a coherent outcome, and suggested that the outcome that the builder and developer were propounding would lead to an incoherent outcome. So that one looked at whether or not there was a non-delegable duty, and if there was a non-delegable duty, that then, because of Section 39, meant that effectively the Design Act trumped the Civil Liability Act. Now, that focus on Section 5Q formed very much part of the High Court's consideration. And in simple terms, I've put up there what the High Court found. So Section 5Q does apply, and the claim is not an apportionable claim. The slide before you now is a more fulsome statement of the reasoning of the court. And again, we're talking about, on the facts of this case, the owners' corporation suing and the builder and the developer. Much of the consideration before the court was in the circumstances that a head building contractor would find itself in. And Stephen is going to talk about some of the other issues that were not decided or have been left for consideration on another day. this is a statement of the majority. I suggested earlier that when understanding this, one had to have particular regard to Section 36 and the definition of construction work. And if you remember, I suggested that Sections 36A and D were the particularly important sections to understand. An important part of the reasoning of the majority was that the reference in Section 37 to carries out construction work doesn't mean that they can avoid the imposition of a duty if they don't actually carry out the duty, the construction work. So there's a difference between there was a discussion about whether or not section refers to carries out construction work or does includes the words agrees to carry out construction work. And so the court found that the appellant's argument, which would read into the words of the section agrees to carry out the construction work, was not to be accepted. The minority judgment is interesting for the reasons that the difference in construction that their honours applied was so finely tuned to some of the points that the majority reasoned in support of their decision. Example, the majority held that their construction was consistent with the policy objectives of the Act and gave effect to all principal provisions of the section, in particular Section 39 of the Design Act. When the minority came to look at the point, they reasoned that their construction did exactly the same thing. And as lawyers advising, I think that's one of the interesting things is to understand how closely those incredible minds differed and used those same supporting principles in support of their own reasoning. Some of these points I'm going to leave for Stephen to discuss, but as I said, the minority judgment is very interesting because of the points it raised in terms of the practical impacts of the majority's reasoning, and Stephen is going to expand on that. So I'm going to hand over to Stephen now, and he's going to take you through the next part of the presentation.
Okay, so in terms of what was not decided or questions that remain, I've identified 3 issues, and I'll deal with them in ascending order of importance, at least from my perspective. So in this slide, we start off with quite an arid debate as to the interaction between subsection 7.3, which is out there on the slide, and the duty of care under section 37.1 of the Design and Building Practitioners Act. So this argument was used by the appellants in Pafburn to support an argument that the duty under section 37 can only relate to construction work you actually carry out and not construction work that you may have agreed to carry out but someone else performed. So the critical things to look at in the slide, subsection 2, a principal contractor means a person who agrees to do building work under a head contract. And then under subsection 3, by virtue of being a principal contractor, they are deemed to be a building practitioner who is taken to do building work. So building work ties in the definition of construction work in part 4 of the Act, and then is used in section 37, which refers to a person who carries out construction work. So the appellants in Pafburn submitted that the Design Act should be read harmoniously so that the phrase carries out construction work should bear the same meaning as, in the various parts of the Act, including the criminal provisions. And if it meant that it not only included a principal contractor's actual acts of building work, but also extended to matters that it agreed to undertake, that could impose criminal liability on the head contractor or the principal contractor, work it hasn't even done. Now, the majority disagreed with this proposition that criminal liability would attach to a principal contractor for work done by a subcontractor. And I note that the criminal provisions are not engaged by simply carrying out building work or agreeing to carrying out building work. They're generally defined by failure to take reasonable steps. And I don't know if Stephen mentioned this, but in Part 4 there's a concept of a non-delegable duty of care in Section 39, and that doesn't apply to the criminal provisions. That's by an aside, because the majority actually refused to answer this question. They said it hadn't been considered in the courts below, it was not subject to a grant of appeal, and it hadn't been fully argued before the High Court. So they've left that question for another day. So then turning to what I consider to be the more important issues. The first one is whether certifiers or local council carry out construction work. And this issue came up before Chief Justice Hammerschlag in the Owners Corporation decision there, and Dildon Developments, where His Honour mentioned that this is an important issue that's worthy of appellate consideration, perhaps even by the High Court. The minority judgment held in Pafburn that it's not self-evident that a certifier or local council carrying out their certification functions, which are independent, equate to carrying out construction work for the purposes of the Design Act. And that question really should be remitted to the trial judge for determination on the facts. The majority found that it didn't need to decide this question because essentially the builder and developer had agreed to undertake the whole building and therefore had carried out all the construction work. So the question remains unanswered. And then getting to the more important question, which is whether proportionate liability for subcontractors or consultants can still be pleaded against a claim under Section 37. Now, again, because the appellants in Pafburn had agreed to construct the whole building, they were liable for all defects, so proportionate liability was held not to apply for them. But the key paragraph in the majority's judgment is paragraph 52, where the majority noted that for a person who supervises, project managers, etc., construction of a whole building, their duty of care extends to all construction work. Whereas in the case of a person who supervises only part of a building, such as the foundations, their liability will only extend to defects interrelated to that part. And in the case of a person who only undertakes a specific type of building work, like plumbing, it extends only to defects arising from that construction work. So it's implicit from the majority's decision that proportionate liability is available as a defence to contractors or subcontractors, consultants or subcontractors. And here I've quoted from a section of the transcript where the Chief Justice Gageler asked his rhetorical question: if you are the subcontractor, you actually did the concrete wall, why can you not rely on the proportionate liability provisions? So it seems pretty clear that proportionate liability is available, although the majority did not need to decide it on the facts of the case. And it was accepted by the Owners Corporation, the respondents, that it would be available. I also note that the majority's decision doesn't overrule some first instance decisions. where the Supreme Court has held that proportionate liability may be available. And a useful decision is a decision of Justice Ball from 2023. It's Owners Strata Plan 86807 and Crown Group Constructions Pty Limited number 2, where His Honour expressed the view that there's no difficulty in principle applying proportionate liability, but where you have a non-delegable duty of care under Section 37, then you remain 100% liable for all defects that arise out of the scope of that duty. Okay, so now we turn to practical implications of the decision. In the majority's judgment, they referred back to the insurance crisis that led to the civil liability reforms, and warned that if proportionate liability wasn't available as a defence, the head contractor would be exposed to significantly increased risks and insurance premiums. Speaking to insurers and also brokers, the feedback we've received is that the decision hasn't really changed the landscape. Maybe it's still too soon, but the Court of Appeal decision was handed down in December 2023. In the current cycle, we're actually told that the market is softening in PI construction risk because of increased capacity, and so premiums have actually been coming down. So the decision's not expected to make any impact in the short term at least. And that's not really surprising because it doesn't really change the status quo. So, for example, under the Civil Liability Act, proportionate liability is excluded for the statutory warranties under Section 18B of the Home Building Act, which are not apportionable. And feedback in relation to other infrastructure projects is that generally our clients are being asked to contract out a proportionate liability anyway, and that applies to about 90% of contracts on the anecdotal evidence we've been hearing. And it's also being led by the state of New South Wales, so paradoxically it's asking contractors to contract out of its own legislation. And then head contractors put that forward as a justification to require their consultants or subcontractors to contract out too. Okay, so turning now to practical implications, and this is just tips for conduct of litigation. The minority referred to increasing costs, and if proportionate liability is not available, then basically costs are going to increase because defendants have to bring cross claims to claim contribution from other parties, which adds to the complexity of the proceedings. They're also bearing the risk of not being able to enforce a judgment against impecunious parties. Another thing in practice we've noticed is that as soon as you're served with a claim, you need to immediately consider your cross claims, because often limitation periods will arise. This is often because the Section 37 duty has retroactive effect back to June 2010, and it runs from when loss first became apparent. That's problematic because when considering a cross-claim in relation to defective building work, you're often subject to the 10-year long stop limitation period in the Environmental Planning and Assessment Act, and time under that act generally starts to run from the issue of an occupation certificate, which may be well before a latent defect becomes manifest. So actually in Pafburn itself, the Owners Corporation commenced their proceedings just 5 days before the expiry of the long stop period. And so the developer and builder probably had no time to consider cross claims or to bring them. They may not have been served within those 5 days. And that probably explains why they've gone all the way to the High Court on the proportional liability point. Okay, more practical tips. I put up there 3 cases from New South Wales, including 2 Court of Appeal decisions, which have basically held that people undertaking construction work may have personal liability. So for subcontractors and consultants, that is something that perhaps you can take advantage of. If your builder or developer doesn't have sufficient funds to satisfy judgment, if you can show what particular construction work individuals undertook, they may be personally liable for all defects. So that could be a very useful thing to use in practice. If you've got proportionate liability, well, you just name them as a concurrent wrongdoer. But if you don't have that option, for example, if you've contracted out, well, then you've got to consider bringing cross claims against those persons personally. And then just on this slide, the last thing is that because the appellants had pleaded that the principal certifying authority and the local council had undertaken construction work themselves, the majority held that that must have been part of the construction work that they had agreed to undertake, because they had agreed to undertake to construct the whole building, and therefore proportionate liability couldn't be pleaded. But whether certifiers actually undertake construction work is a vexed and unsettled issue. So if you don't need to plead that, my advice is not to, because basically you're giving up a potential proportionate liability defence. So that's practical tips in litigation. And now just quickly moving to the contracting side. So consultants could try to minimise their exposure by narrowing the scope of works that they agreed to undertake in a contract, and remove from their scope works to be undertaken by specialist subcontractors. So the general rule under contract, but not by tort, is that a consultant remains liable for its third-party contractors, although you can amend that general rule through the express terms of the contract. And although that's a very orthodox position, I have given you there a reference to another Court of Appeal decision where Justice McFarlane made that exact point. So this general rule is provided for in most standard forms, and here I put up clause 9.5 from AS 4902, which is the general conditions for design and construct contracts. So unless the contract provides otherwise, you're basically liable for all the defaults and admissions of your subcontractors. And you always see the final clause, approval to subcontract shall not relieve the contractor of liability. So that's the standard position. We're told that often in practice it's difficult to narrow your scope of works in that way, but an analogous case went to the High Court a few years ago, and it's the Woolcock Street Investments case that was one of the forebearers to the Brookfield Multiplex decision. So that was in the High Court in 2004. It concerned an engineering firm which provided civil and structural engineering services. In that case, there was an issue with foundations for a commercial, I think, complex and warehouse in Brisbane. The engineers were alleged to have designed inadequate foundations, but during the course of their design, they had actually obtained a quote from a geotechnical engineer to conduct investigations as to ground conditions. And the builder's manager didn't authorise the quote. And not only that, was alleged to have actually told the engineering firm what sort of size of foundations to include in their design. So essentially, the owners of that property who undertook the development had not relied on the engineers, and the engineers had not assumed responsibility. So the engineers did not owe a duty of care in contract in respect to design of the foundations, and there was no analogous duty of care which the subsequent purchaser could have tried to establish a case on, and so they therefore failed in their attempt. Now, whilst in practice that could be quite an unusual situation and, as I said, difficult from a contracting perspective to get your head contractor to agree to, in Pafburn you have the situation where you've got like a related builder and developer. The developer could be a special purpose vehicle set up just for that development with no substantial assets behind it. In that sort of case, you can see that it should be quite easy to get the developer to agree to have the builder nominate all the specialist trades and subcontractors as not being within its scope of works, and that may assist the builder to minimise its exposure because it doesn't really owe a non-delegable duty of care for contractors or subcontractors who are not performing work that is delegated or entrusted responsibility to. So that's just one practical tip that I thought could be used. And then what's happened? Okay. So I did actually come across the sample clause in practice quite recently, and I thought this was being used to ameliorate the effects of the majority's decision. Ah yes, there it is. Oh, can we get that one? Okay. So there's two things to notice in this clause. The first is that there's a requirement that the consultant is agreeing to act as the agent of the head contractor. That's probably a requirement that's being passed on by the principal, and it doesn't really affect the position under the Design and Building Practitioners Act because if the consultant is the delegate of the head contractor under section 39 of the Act, where there's a non-delegable duty of care, the head contractor is liable for its acts and omissions anyway. Agency really only applies outside of those provisions. So it means by being its agent, the consultants, their acts are essentially taken to be the acts of the head contractor who bears vicarious liability. But the more interesting thing is really clause 3, where the consultant is being asked to take joint and several liability. So based on the majority's decision, the head contractor may be liable for all defects. And so that could vastly expand the exposure that the consultant has to claims. And just from a practical perspective, and coming from this from an insurance angle, accepting that liability could have issues under your PI policy. One, if you're accepting liability for work done by the head contractor or its other subcontractors or consultants, that work may not relate to your professional services, so it may not be covered. And two, often these policies have a contractual exclusion, so you're excluded where your liability is assumed under contract and would not otherwise have applied to you under the law. So those are my points, and I'll pass on to James for other industry and insurance perspectives.
Stephen, much appreciated. I'll talk a bit about the impacts of the Pafburn decision on the construction sector more broadly and on the insurance sector as well. So where are we now? As we know now, what the decision means for head contractors who've entrusted certain aspects of the work, i.e. to a plumbing subcontractor, for example, the buck stops with them, And so if the subcontractor has caused the issue, then it's comes back to the head contractor, and the same thing applies for developers. Practically speaking, the impact of Pafburn on builders and developers where they previously relied on these proportionate liability defences, they can't do that anymore, obviously. And so what needs to be done, as has been touched on, is cross claims, and so that's been the position since the Court of Appeal decision. We've all been doing that since that time. And of course, as we've talked about, it increases litigation complexity and cost. I've got a matter at the moment involving a typical apartment complex dispute, and I had a look this morning to see there was 12 defendants, so the owners had sued 12 defendants, and then one of those was the builder, and the builder had cross-claimed against 9 different cross-defendants. Now, the price of a cross-claim is $3,700 per cross-claim, and so there is $33,300 in cross-claims that would otherwise not have been incurred in a pre-Pafburn world. Another big part of the decision is that it means that if you are an insolvent party that's responsible for loss, so work with me here, if you've got a head contractor, you're a head contractor, you engage a subcontractor that becomes insolvent. Previously, in the pre-Pafburn world, you would just plead proportionate liability, and as a result of that, you wouldn't be liable for the loss and damage of the insolvent contractor, but because they're insolvent now, you're liable for the losses that flow as a result. And this is not an altogether unlikely scenario, as you can see here. These are the latest ABS stats in terms of insolvencies. Construction is, by leaps and bounds, the industry furthest ahead in terms of insolvencies, and it's 70% up from 2023, which is the light blue figure there. I remember looking at these stats in 2023 going insolvencies at record highs, but now it's more than that. So it's a relevant consideration for your clients because they're going to be liable for the insolvency of these subcontractors. You need to work out how you're going to minimise and mitigate that risk. Stephen's talked a little bit about things can be done, but contractual indemnities, contractual protections, that sort of thing. It's not going to get you off the hook in terms of insolvencies, but that's your best bet. The other thing we've noticed in recent years is in terms of D&C contractors, the trend has really been to say the buck stops with you. I'm a D&C contractor. I've got sub-consultants, I've got subcontractors, almost as if they're a post box has been the trend in recent years. And it's a risk mitigation tool from their perspective. But with Pafburn, they're going to have to really monitor the performance of their subcontractors and sub-consultants as a result of the decision, so as to prevent the likelihood of further being responsible for further defects. And this all comes at a time when housing starts and housing approvals are not where they should be. You can see we are latest stats September 24. If you compare that to June 2021, when we were at the peak of COVID, people going crazy with home builder and so on. And both in terms of housing starts and housing commencements, they're way down from where they should be. New South Wales is causing those figures to pronounce more because its housing approvals are down by 10%. And what this means is that the Australian government is not going to hit its targets in 2029 of whatever million properties need to be built. And the point of this really is that with the increased risk for builders and developers and the fact that there's less builders because of the insolvencies, that's going to have a negative impact on consumers because of increased construction costs by virtue of them having to account for this risk, increased construction costs due to less competition, and also for consumers a lack of much needed housing stock coming onto the market. So what's the impact on the insurance sector? Stephen's helpfully touched on some of this. I'll take it a little bit further. As Stephen said, if you look at the blue arrow up there, you can see that is where we're in the PI complex sort of arena, and the pricing says increasing. This is from Bellrock, by the way, insurance brokers. That's more to do with the fact that geotechnical engineers and structural engineers have had real trouble getting insurance cover. It's not due to do with Pafburn, and as Stephen also said, the green arrow down below says there's a bit of capacity in the market, which means pricing is going to be stable. But what Pafburn really does is it puts the spotlight on builders and developers, and the main types of policies that are going to respond to those are going to be your design and construct PLI policies, right? So now, if you're familiar with those, they cover things like design, specification, supervision, okay? They exclude things like workmanship, installation, and so on. So what insurers are going to be doing is having a really good look at the claims that are being made against these insureds and whether they really truly arise from something to do with specification, design, supervision, or really they're due to the acts of the subcontractor, which has to do with workmanship, installation, and so on, in which case those claims wouldn't be covered. And so the point there is really that, you know, there's an increased need for insurance coverage, but the type of insurance cover that's available isn't the perfect fit for what the Pafburn decision throws up in terms of additional risks. So in terms of managing risks, insurers are going to do the same thing as your clients. They're going to apply rigorous scrutiny to their insureds. They're going to apply rigorous scrutiny to the insured's counterparties and so on. And some insurers in the market reportedly have adopted a practice of seeking to exclude claims for Design and Building Practitioners Act. So they will say you're not covered for these claims. You might be covered for everything else, but for that, it'll be an uninsured risk on the part of the insured. So just something to bear in mind if you're looking into those things for your clients. That hasn't really been tested in the market, that wording, as yet. So interested to see what happens. The other thing which we might touch on a little bit later in Stephen Ip's next section, if we have time, is decennial insurance. So that's the 10-year insurance product, also known as latent defects insurance. That might be something that developers can use. And what happens there is a developer buys an insurance policy that covers the owners for things like structural, fire, waterproofing. It's a policy of first resort, so it means that the owners aren't going to have to go and sue someone else to get coverage under the policy. And so that is a potential avenue for your builder and developer clients, and it occurs in a less adversarial environment. There aren't too many of these policies in practice as far as I can tell at the moment, but I did have a scout around. I wasn't just looking for property, I was just looking for latent defects insurance, but you can see here this is the Dank Street district that's being advertised for sale, and they're advertising the fact that they've got a latent defects insurance policy there, so it makes it more attractive to purchasers and so on. So developers are clearly using it to some degree, and also using it, no doubt, as a marketing tool. In case we don't get a chance to mention it, the decennial insurance and the LDI insurance is something that has been proposed to be introduced as mandatory as part of the building bill that Stephen will touch on next.
Thank you, James. Very briefly, just a key point to understand is a lot of this might all go away, but that's the big unknown. The building bill is going to consolidate 9 existing acts, including the Home Building Act. So the real question is, what's the status of the building bill? We don't know. It's kind of in the deep freeze, potentially because they've been waiting to find out what the High Court's going to do on Pafburn. On the one hand, you could think that the legislature will effectively fold in all of the current provisions of the Design Act and the effect of the High Court decision in Pafburn into the building bill. But there's some uncertainty that there might be some amendment as a result of the Pafburn decision. So it's a wait and see as to what is going to find itself in the final form of the building bill. That just gives you a bit of a timeline as to the building bill. When it came out, it was open for consultation for some time, and its current status is unknown. So that's really the formal part of the presentation that we've done. And we unashamedly borrowed this concept of back to the future from somebody else who's written about this. And we, I think speaking for James and Stephen, we consider that really where we are now is a point back to prior to 2002. Now, an interesting question is whether that's an unintended consequence. When you do read, or if you do read the second reading speech, I found it of interest that you don't find any reference to proportionate liability in there. Not a word. There's a reference to the Civil Liability Act. Now, the submissions before the High Court said that the respondents submitted that the Parliament had considered this, and this was the natural outcome of the intention of the legislature. You may or may not agree with that, but that's an interesting thought. Another interesting thought that you may want to discuss with us is whether you think that the consequence has gone too far. Has the balance gone too far in favour of owners? Is the risk profile that James and Stephen have identified, is that now too onerous? And depending on who you're advising, you may well have different points of view. So, James or Stephen, do you want to finish off with some concluding remarks?
One thing we didn't mention was the fact that this was really a ringing endorsement of the New South Wales DBPA. So this was really a fulfilment of legislative intent. Make no mistake about it, and the fact that the majority judges were all from New South Wales. I don't know, maybe it means they've seen what's happening on the ground here and wanted to implement that in some way. But the fact that whether this was all intentional about the interactions of the Act and so on, I think the fact that the court was so divided on it suggests that it probably wasn't, because they were finding it quite difficult to interpret, so it was so straightforward. Why were they so at odds with one another? Yeah. And
that, just to pick up on that, I think it's if you talk about the concept of complexity with the application of this Act, it's been stated a number of times at first instance levels, was stated in the Court of Appeal, and was again stated in the submissions before the High Court. So, as I said, the reasoning of the majority and the minority, when you compare the points that they used to support their outcomes and how close they were, is a reflection of the complexity of the arguments. Stephen, do you want to sign off with something?
Yeah, so from consultants or subcontractors' perspective, I don't really think it changes the landscape, but as I said, it may actually give you forensic advantages, because there is this personal liability, and a building superintendent or project manager is someone who can now be in your foresight, either to recover money from or to name as a concurrent wrongdoer. So that's quite helpful in practice, I think.
Thank you. Well, we're now finished the formal part of the presentation, and invite a more open discussion.
Stephen, I think we've lost our online audience, so if there's any questions online and we can't bring you back, please email them through and we'll answer them.
All right. One of the things I want to throw open to you is that we've been talking about, as the High Court considered, really the question of owner suing builder and developer, and much of the discussion, as I said, was in relation to the position of a head contractor. Many of you, and Stephen has touched on this already, have you considered the position of suing directly the subcontractor? So when looking at this, I thought it was helpful to understand that this concept of a non-delegable duty, you're really looking down the contract chain. Now, what happens if you look up the contract chain? Does proportional liability still apply, and what circumstances? And so that's some of the matters that really were not addressed. And would any of you like to take that on board and discuss that?
I'll say something.
Thank you.
I'm usually on the plaintiff side of the fence. need help with the owner's operations when the builders went under. So previously we wouldn't have that available given the brick build, but now it's something that certainly are looking at. It's complicated because of the volume of cost payments that we're seeing. But I'd say from a plaintiff perspective, it has been a great introduction, a great legislative reform.
And just taking that point up from a first response to the decision of acting for an owner, you would think the owner's position has been substantially improved, obviously.
Yeah.
But do you agree that when one comes to actually apply the Section 37 duty, that's really where, for a plaintiff, you do run into considerable issues of cost because of the complexity of proving the nature of the defect, where the defect was in relation to the building, who's responsible for the defect, when the defect arose. All these sorts of issues have to be identified with enormous specificity. And that cost impact on owners is again another impact.
Oh, it's extraordinary, and it can be extremely difficult when the owner's corporation, they don't have a lot of material, they don't know, particularly they may not even know what subcontractors were engaged. So where you don't have that material, you have to consider preliminary discovery to get a lot of documents to find out who was contracted, what work they're responsible for. And until you have that information, it can be very difficult, particularly if the builder has already entered liquidation and they're not available to tell you who they would point the finger at in those circumstances. And just toying with the interpretation of construction work and pointing out what construction work, now we do have to do this post Pafburn, what construction work were they responsible for, and then ascertaining what defects were pointed to against those defendants. And it can be extremely complicated when you might have 60 subcontractors that were involved. So it has extraordinarily increased costs, not to mention the Lulatch decision as well, and the owner's corporations to particularize those claims. And then I think, well, we will find it extremely difficult at hearings is if, say, you have sued a superintendent for supervising all of the work, but then you've also sued the subcontractor for efficient waterproofing. Then you may have also brought in the certifier after signing that off. So how will we divide that once it comes to hearing?
And that overlapping scope of the duty is a really critical question that thank you for those comments. We're all grappling with. Another interesting point that the minority made, you may have seen where they refer to the situation where you plead both a common law duty and a statutory duty, and the different consequences that apply. Now that's a real practical conundrum that I'm seeing, that, and some of you may have encountered that already and are dealing with that question, and that's one of the consequences of this decision. That it may be advantageous to plead both, and you want to be conservative if you're concerned that on your common law duty you might have some difficulty in establishing the duty. You then run to your Design Act statutorily imposed duty, but then you'll have these consequences of pleading and proving your case under the Design Act. So that's the conflict that can arise in running these sorts of cases. Gretel.
I think the minority raised it, but do we not find it slightly unfair that a head contractor who may not have the expertise in plumbing or electricals, they rely on their subcontractors to do the job properly, but now we're saying, oh, actually, you're going to take liability for all of it, even though that's not your expertise. The minority, they said, if you actually carried out the work, you're liable for that. The head contractor or the developer, they're not actually carrying out the electricals, they're trusting their subcontractors to do it properly. I just think this decision, it's just ignored that. It's ignored that you're meant to trust your subbies to do their job properly.
Well, but the head contractors choose the subcontractors. They have the option of choosing a higher price one that will do the job properly, or someone that's cutting out and obviously can't do it for the price. And the head contractors have, up until now, chosen the cheapest option because they've had no liability.
But
This puts the onus on the head contractor to actually have someone to review their work.
But if
And-
the subcontractor has been licensed by the New South Wales government to be able to complete the works, should you not be able to allow that?
No,
I think they will go
they
Well,
should be able to
but that's
have
You
some
do
sort of
have
independent overview.
but that's the discussion that's taking place here is typical of the two competing policy objectives, and so if you think of the Design Act as the legislature's response to decades of bad building, it's going to have these, and does have now as a result of the certainty provided by Pafburn to head contractors, it's going to have this really harsh outcome for head contractors. But if you're an owner, then an owner will say, well, we're only getting the protection that we deserve, and so that's the competition. But then, if you're a head contractor, and we've touched on this, what are the steps that you can take to protect your interests? And on larger projects, you might consider engaging a superintendent, a supervisor. Now, obviously, that'll add significantly to the costs of the project, and the smaller the project, the less likely that sort of step can be taken. But that's I mean, Gretel, when you say that you don't think that was considered, I respectfully differ. I mean, I think that the majority considered very carefully the policy objectives behind the Design Act, and really looking at, well, we've got Brookfield, and that's a consequence of Brookfield, and there needs to be consumer protection. So the minority judgment, remember when we looked at the definition of construction work, and we looked at building work in A and supervision and substantive control in D, and the minority said, well, the head contractor is liable just for that work in D. So if the head contractor does some kind of supervision as part of its substantive control, it's liable just for that supervision. It's not liable for the carrying out of the building work because it didn't carry out the building work. The subby did. So the minority went obviously further than the appellants. That was issue 3, but the majority said no. They said no. That's why this is so significant when looking at it. This duty extends beyond further than where we've been before, in circumstances where you, the head contractor, haven't carried out the work, and you're liable for something that somebody else has done. So, looking at it the way you do, that's a very neat exposition of the different competing principles.
Can I just add there that this was a submission made by the owners before the High Court, that the Design and Building Practitioners Act is really the specialty, whereas the Civil Liability Act, Part 4, proportionate liability, are like general provisions. And in terms of statutory interpretation, the special provisions should take precedence. So they're giving effect more to the statutory intention behind the Design and Building Practitioners Act.
I think what I struggle with is everything, the whole idea is to improve the overall building products in New South Wales, and we know that that's a really valid need. But every time we try to do that, it becomes more and more expensive to do so, and we're trying to build houses for people at the same time. And so, when the DVPAA was introduced, that was after a time when there'd been a mining boom and a building boom, and there'd been no regulation. And now, the economy's not going so well, and we're expected to wear all these upfront costs with the idea that, okay, this is going to be better down the track, right? And that's just one thing I struggle with. Everything is going to be an improvement, and I'm a glass half full guy that, okay, it's going to be a better future, but it just feels, I sympathise with your comments that it feels like a lot.
It's also encouraging her contractors to find ways that they can abscond of responsibility and perhaps not have that same oversight that they would typically have because they're trying to avoid that liability. So I've seen on some projects in situations where you've got developer, builder, same entity, or sort of a holding company as a developer, having sort of construction management services agreements where they're entering all their subcontractors as agents, and they're just basically a manager to try and avoid those sorts of situations. I think it might go in the wrong direction, in that people will be finding ways to be less involved in these higher risk areas in a way that they probably could have helped control quality and issues by just having that expertise and that oversight, but avoiding being involved at all to avoid the potential consequences. I think it's costly, and perhaps removing a willingness to be involved in something that might help avoid defects.
That's a good point.
I think that's a very interesting observation, and again another unintended consequence. But another thought that occurs to me when advising clients about projects and at the early stage is identifying with absolute precision what's the scope of work. And I think if ever there was a need to focus with your clients and those advising your clients to identify with great particularity what's the scope of work, because ultimately you, when the difficulties arise in the project, 5-10 years later, there'll be people like us poring over exactly what was the scope of work, who was responsible for what and when, and being able to prove that, as we've spoken about, is the costs of doing so. So those organisations in the industry who are better equipped at doing that will get certainly a step up in the implementation or the outcomes of the Pafburn decision.
I was going to ask that the Design Act is primarily focused on Class 2 residential unit buildings, but it references the Home Building Act, which brings in Class 1 and a couple of other things. What sort of impact do you think this will have on the standalone residential developments?
Well, currently the regulations provided applies to classes 2, 3 and 9C. The building bill in its draft form suggests that it's going to apply to all classes of buildings.
Yeah, but the Home Building Act also applies to Class 1, and construction work is covered under design and building practitioners. So you don't have to submit the regulated designs, but I've seen a couple of cases where Class 1 buildings are bringing in this duty of care.
Yeah, so the intention is it's all going to be wrapped up. It's the extension
under
of the
existing legislation, not under the future building bill.
well, according to the draft building bill, that's the intention.
Right.
That's where they'll get to. So there will be uniformity in terms of classes of building to which the duty of care operates.
I think it might be too expensive to run for just, a normal homeowner. If you have several lots funding the action, it might be worthwhile bringing a DBPA action. But, an individual homeowner to bring something like this with the Lulash schedule, and then you have to go and get all the defects that the builder is now responsible for. It's so expensive
Yes.
to run. So I don't know how many Class 1 buildings will be seen using this act. Yeah.
Yes.
Unless you're a subsequent owner.
We have a question over here.
Even if this is excessively semantic, but do you think there's any help in seeing it as a statutory indemnity rather than a statutory duty of care?
In what way?
In the sense that the person who's liable might not really have anything to do with the work that's done, or have any means of actually exercising a duty in practical terms. And therefore it's a little bit like an indemnity in the sense that whatever happens, you're liable for it.
Yeah, I think that's a good way of looking at it. I agree.
The only difference is you've still got to prove it somehow. And with an indemnity, you don't have to prove too much. But
And when you look at Section 37(1), it's a duty to exercise reasonable care to avoid economic loss caused by defects. And those defects could have been caused by a number of different actors. But whereas in that decision, you're responsible for the whole building, then you're lumped with liability whether you did it or not.
My obviously there's another issue that comes up which is not directly related, but in terms of the employment contracts with the consultants, etc., that now all got personal liability, but do they have, if they leave that company, do they still have access to that information for their defence? So what access rights do they then as an employee have long term after they leave employment to projects they've worked on to prove that potential liability or defence?
Well, the point that you make, and it's worth stating for everybody, that the personal liability attaches to the individual, and that flows from the decision in Boulos and a separate decision in Kazi. So yes, that is, I believe, a matter of concern to some in the industry of the nature of that personal liability.
Hopefully your insurance kicks in because you are required to be indemnified.
Yeah, but the question comes when you change companies, does that insurance follow you? Or they cease to exist?
Well, I mean
and
that's a
take
question of contract. So it'll depend on the terms of the employment contract and the insurance provisions that are operative at the time.
I don't know the answer to this, but if you're an employee and you're personally liable of a company and then you leave, isn't your employer going to be back you for being vicariously liable for your acts?
Well, yes, except if they go bankrupt or they go into liquidation.
Yeah.
Which is, as your slide showed, a major issue.
Yeah.
If they're a continuing issue, they should be protecting you, but if you left and they go into liquidation, you've got a 10-year period. They can easily liquidate before the liability comes up, and therefore those records are being difficult to obtain. So do you have as an employee a right to obtain all your notes and everything else you've done on a project?
Find out who your employer's insurers are before you. Yeah.
So it's PI, which is a 12-month thing, so it's...
And notify early and often. Yep.
Yes.
I have a question in terms of section 36(1)(b), having substantive control over the carrying out of the works.
Yes.
If in a situation you have a owner or developer and there's a shareholder, a majority shareholder, who has substantive control over the company, then the nominated supervisor has breached their duty. Can you still go after the majority shareholder because they have control over the company?
Well, the question that you ask gives rise to this notion of able to have substantive control, or actually does have substantive control. And the Court of Appeal has answered that affirmatively. So the answer is, if you're able to have substantive control, you're on the hook. So Justice Stevenson held that in one of the earlier Pafburn decisions, again, the first instance, and there was some uncertainty, and in fact, in the High Court, the appellants submitted that question was outstanding and to be determined finally elsewhere. I do believe that it has been determined, at least at appellate level, in the Kazi decision. In very, very short, succinct statement. There's not much by way of further consideration. It's an acceptance of the principle that if you're able to exercise substantive control, you have it.
But there's a difference between that and being a majority shareholder.
Well, I was thinking more, if you're a majority shareholder, you have control over the company, you have control over the employees.
No, it's more to do with being able to exercise some substantive control over what's happening on the project. So just because you're a majority shareholder doesn't mean that you can do that, right? You might be a majority shareholder, correct me if I'm wrong, I don't want to Stephen it, but that's my understanding, is that just because you're a majority shareholder, you might have nothing to do with how the company's run.
Well, it's a question of fact. Remember, the courts have said this consistently, that whether or not you have substantive control will always be a question of fact. But for some time, there's been a sort of neat dance around this issue about, well, I'm a director of a company, for example. I'm also the nominated supervisor. But I actually never went to site. I delegated that responsibility to somebody else. So I wasn't there. So I've seen people take the position that means that I didn't have substantive control. in my view, the effect of the Justice Stevenson and the Court of Appeal's decision in Kazi is that the position is now if you're able to, that's enough. So it doesn't matter if you just didn't turn up on site because you thought somebody else was going to and you delegated that responsibility. If you're able to, you can. Now, the question that you raise, there's an extra layer of complexity that goes to the effect that a majority shareholder does have on the acts of the company. As James says, that's a question of fact as to what impact it would have had on site. I mean, if the majority shareholder was giving directions, had the capacity to give directions to a project manager as to how the project was to be delivered, for example, then that would be a highly relevant question of fact. Yes.
This issue of substantive control, obviously it's not absolute actual control. There's got to be some threshold where it's substantive. When we're talking about companies, it's easy to imagine the companies being a number of different people all acting at once. In that sense, the company, just in the same way vicarious liability acts that make the company liable for all the actions of all the people, it makes sense that a company could be substantively in control of the actions of all the people under it. But when it comes to an individual person, it would be entirely impossible to even imagine how one person could actually be substantively in control of every single action that occurs on site, specifically in situations where some activities require multiple people to be acting at the same time. Do you think there's any scope for an individual who's sued under the DVPA to try to address the question of whether they are actually substantively in control of something that was done by another person?
Again, a great question, and we're talking about identification of scope of work. Put another way, who's doing what work, where, when, and so you might have a concrete pour, and there might be a number of persons who are involved in carrying out the concrete pour. The person doing the concrete pour, then there's a supervisor of the concrete pour, and whether or not somebody who has alleged to fail to take reasonable care in the carrying out of that, there will be a question of fact as to, namely, that exact question. Is what that person did within the meaning of substantive control? But it's not substantive control as to the whole of the project. It's substantive control for the carrying out of that specific work.
And you may have substantive control just by the fact that you've contracted with a subcontractor, and so you're able to determine how they undertake their work and what sort of standards they have to comply with.
It does seem to raise this whole issue, which was brought up by my colleague over there, which is that the reality of building is that the person at the top isn't actually in control of what happens, and it's not expected that they are.
That's right. Well, and what this does is it flips the onus onto certainly from the head contractor point of view, to now take that responsibility, whereas before it wasn't. And that's the startling reality of where we are. But again, I ask myself, well, is that sledgehammer approach going to achieve better building in New South Wales? The legislature thinks so. Until the next crisis. Any more questions? Otherwise, we'll move for a drink and a further discussion, more informal discussion. Any final questions? Well, thank you very much for everyone's attendance, both here in person. We're very grateful and for your questions and interaction and your observations. They've been very interesting. And of course, also to those online, those watching now and those who will watch this in the future. Thank you for your interest.